developer purchased property in 2012 in the Franklin County area of North Carolina, which is essentially now a suburb of the Raleigh area. And when it did so, it had a piece of property that was subject to an approved preliminary plan. The approved preliminary plan is found in the joint appendix under page 44.
Right, we've seen that. So your argument is that the plan created a vested property interest in water and sewer services, correct?
That's part of the.
All right. Well, what effect does the settlement agreement have on that claim?
Sure, Your Honor. So with respect to the settlement agreement, they've made much of that contention. First of all, with respect to the settlement agreement, there is a portion of the agreement wherein the parties agreed. Sorry. So we have to look at what the settlement agreement says and what the settlement agreement doesn't say. And so with respect to the settlement agreement, so first of all,
are you about to point me to the precedent provision in the settlement agreement that you cite in your complaint?
Well, a couple of things, Jen. I'm about to point to the recitals are incorporated by reference.
All right, go ahead.
So the parties agree, and this is appendix page 80, paragraph 15 of the agreement. The parties agree all the foregoing recitals are incorporated by reference here, and they form a part of this agreement. If you flip over, Your Honor, to the recitals themselves, it's clear at the outset in the whereas clause, the second to last paragraph on page 76 of the appendix, developers and county disagree over whether developers may develop the property in accordance with the preliminary plan, including all of the conditions set forth therein, given the date of the approval of such plan, whether developers are subject to the WSAO, which post-states the plan, and to what extent the UDO and the WSAO is applicable to development of the property. So first you have the understanding there that there was a question as to the applicability of the WSAO. Then you have, Your Honor, what is actually carved out of the agreement. If you look at what's carved out of the agreement in the appendix, page 78, the county agreed that the preliminary plat has been approved by it. Doesn't say by what date it agrees that it had been approved, whether it was approved back in 2005 or whether it was approved that date. Now, has been approved by it, notwithstanding the date of such approval, developers may proceed to develop their property in accordance with all of the terms, covenants, and provisions of the preliminary plan, except as set forth herein. Any vested rights accorded to the property under the preliminary plan approval shall not be modified or supplemented by any subsequent action, including ordinance, rule, and or regulation of county. And what the district court said on that issue is, what do they mean by any vested rights? And the district court
it seems pretty clear to me. What it says is this agreement doesn't add to or subtract from any rights that you would have otherwise had absent this agreement. That seems like the most logical reading of that to me.
It does, but what the district court's reading of it was on page 141 of the appendix, the term any vested rights accorded the property under the preliminary plan approval is itself unclear as to whether the parties agreed that any vested rights exist. So
I would agree with that as well. I mean, so then it seems to me it just reduces to the question of, did you have any vested right before this agreement? And then I guess my question to you is, can you identify any local ordinance or any other source of authority that says a preliminary subdivision approval creates a vested property right?
Yes, Your Honor. So actually, when you look at this issue, you look at state substantive law, right?
Sure.
The North Carolina Supreme Court in 2015, Town of Midland versus Wayne said, and we must first determine the property interest affected by a combination action, but they say they're analyzing this based upon common law. The trial court determined the defendant had a vested right to develop the property under the 1997 plan. At common law, government may not deprive a landowner of his right to continue with an approved use of his land when in good faith reliance upon valid government approval, he makes substantial expenditures and incurs significant contractual obligations. Here, it
But
was.
they have to apply for water and sewer allocation. It hasn't been approved.
Well, if the WSAO applies to my client, there's a requirement for application. We contend that with respect to the WSAO, which is their allocation ordinance that they adopted in 2019, it doesn't supersede the property right that we had.
What about the settlement agreement that says developers may apply for water and sewer allocation effective in 2020?
So, Your Honor, with respect to that, we did apply, and that was to keep track of their census, because if you look further down in the ordinance itself, they have to take a census of actual water usage. So as Your Honor said, it didn't take away any rights that we had. It maintained the status quo as to the rights. We applied for ministerial purposes in order to get their census is our position in the complaint.
Well, your view is you applied for ministerial purposes. Their view is you applied because you still had to apply. Which comes back to the question.
So back to the question about whether or not there's any precedent for this. The answer is yes. Defendants approved multi-phase residential development plan, a preliminary planning followed by phased implementation is consistent with the inherent nature of residential development. So this was an approved preliminary plan. Not talking about what they say is it just has to be a permit, or it can be a writing, it could be an approved preliminary plan. So that's the Supreme Court of North Carolina. If you, in good faith reliance, make substantial expenditures of money, time, and labor based upon, they said that they've made expenditures of money, time, and labor based upon this 1997 plan. The town argument that the expenditures were directly related to some other phase ignored the unified nature of the plan and the benefit of the expenditures to the entire subdivision. So to answer your question, Your Honor,
So why isn't, can I ask you just a question, a framing question? Why isn't that a takings claim, not a due process claim?
well, you have a property right.
Right.
So the underlying issue here, Your Honor, is whether in that case, it was a condemnation action. But if you're looking,
Which is, I mean, it was a condemnation action under state law, but I guess the closer federal constitutional analog to a condemnation action is a takings claim, not a due process claim.
Your Honor, this is a taking of our property. It's a due. The question is whether or not we had a property interest that we were vested in that was taken from us. And so,
Sure, but these are different constitutional provisions. One provision says life, liberty, or property cannot be taken without due process of law. Another one says public property cannot be taken for private use. Sorry, private property cannot be taken for public use without just compensation. Condemnation actions are classically analyzed to takings claims, not to due process claims, right?
Yes, Your Honor, under state law, that would be correct. But what we're looking at here is under the 12B1 analysis that the district court made, right? Which turned entirely on a facial analysis of this complaint. At this stage is, the district court agrees that if we had a property right that was a vested property right that was taken away, and we think this court would agree that that would establish a claim under the 14th Amendment that we have here. So while that analysis was done,
well, if you had a property right, then the due process clause says you have a right to have it not taken without due process of law, not you have an absolute right to never have it taken.
right. And in this instance, there's absolutely no evidence that there was due process of law. I mean, that we had it, it was taken, they adopted an ordinance. There's no evidence.
So let me get this straight. So your view is that you had a right to install this water stuff without any permits from anybody at all. I mean, do you have any evidence that any other entity received water and sewer services without, after this statute was passed, the WSAO? Is there any other entity, as far as we know, on Earth that has ever received water or sewage services without having to apply in accordance with the ordinance? Has anyone else gotten to do this?
So, Your Honor, that is the crux of this matter. You're asking about evidence, right?
Well, so let me rephrase. Have you alleged that anyone else has ever gotten to do this after the 29 ordinance?
Yes, Your Honor, we have alleged that under paragraph.
Without applying?
Yes. Let's see. Other similarly situated entities who develop your land within the preliminary.
Which JA side are you reading from?
Paragraph 122 in the action argument. We allege that other similarly situated entities who developed their land within the preliminary plan received water and sewer allocation without having to comply with the restraints and constraints set forth in the WSA. So when you're talking about evidence,
That's it? That's the allegation?
That is the allegation at this time, but if you look at under equal protection claims, they have all the evidence of that. How do we know what the evidence of whether anybody, we're at a pleading stage.
Wait, are you saying you allege something
Right.
without having sufficient factual information to allege it?
But we know for a fact that they have that
How do you know that for a fact?
there are other entities. First of all, we alleged that we were treated differently and that other similarly situated entities developed their land within the plan without having to comply with restraints and constraints.
And what was the basis of that allegation?
The basis of that allegation was that, and I have to go back at the factual aspects of this, but essentially there were other developers that were similarly situated to us, and we, in particular, we looked at under the hearing, utility advisory, joint JA 103. There were some entities in here who were subsequent to us in time or whatever priorities this was, that received allocations at the same time that ours were denied. And that's JA 103. So if you're looking at allocation request from this advisory committee meeting, you're taking the evidence that's
That's also the JA site you use for your statement in your brief that the committee determined it would not and would never recommend that PEM's application be approved. Where, I don't see that on that JA site. 103.
So, Your Honor, with respect to the never being approved, yeah, that's actually within the ordinance itself. If you look at who isn't, that's on JA 68.
Well, that's my confusion. Then I'll look because your brief cited JA 103.
As to the why it would never be approved, that was the meeting in which they did not grant the approval for that application. If you look at who can grant the approvals, Your Honor, it's JA 68 to 69.
No, so where's the meeting that where can I look for support for your statement that they said they would never grant your approval?
So that you can look for support in that, Your Honor, in the ordinance first, which says, except.
What are you reading from? JA what?
69, Your Honor.
Thank you.
Except those allocations which may be approved by the director, which is not the case. Every other request for a new allocation of water and sewer must be approved upon action by majority vote of the Board of Commissioners. All requests, except those approved by the director, must first receive recommendation by the Utility Advisory Committee before being presented to the County Commissioners for consideration.
Okay, how do you convert that to what you said in your brief, which is, quote, the Utility Advisory Committee determined it would not and would never recommend the PEM's 2020 application be approved?
So, Your Honor, with respect to the application, that was the meeting at which they can, and we're getting into the evidence aspect of this, which is entirely the argument.
I'm just trying to get into the veracity of what you said in your brief.
Sure. So that was the application process. The UAC would have to recommend that particular allocation be approved by that application.
All of this sounds like they have discretion in denying or withholding approval for your water services. Is that correct?
No, Your Honor, because what you're looking at with respect to discretion is the question on discretion is whether there was any discretion back in 2005 when the plan itself was stamped approved. We had the water approved. The requirement was, and it was a bargain for exchange. We had to put infrastructure in that they connected to in order to build in this development. And so it's a notion that this was not a bargain for exchange. We bought this property with these water rights. We spent $100,000, substantial expenditures. So under North Carolina state law, that is a vested property right that my client had.
Mr. Nichols, could you just clarify, going back to the facts of the case, the plan that you're relying upon, what is the property interest here that you think you have?
So, Your Honor, there's an interest in, first of all, it could be a true property interest, which the court skipped to whether it's a benefit. So it's a property interest could be an interest in a benefit. Interestingly, the sewer allocation.
So what's the benefit here? The language in the plan, this development will be served by Franklin County with water and sewer to be installed by the developer. that was some of the language that was cited. Is that the language you're relying upon that creates the benefit, the property interest?
Yes, Your Honor. So they provided us with water and sewer. We provided them with roads, left.
Does it say that they have to give you an unlimited amount of water? Because I thought your concern was, you're arguing not just that they're providing it, but the amount. Isn't that what you're challenging?
Well, not necessarily the ounce. Under this ordinance, they don't have to provide us anything ever. The question is whether we had it and they took it away. And we had it at any amount and they took it away. Not the subsequent allocation, which is their argument, is we just had this unfettered right. They could get more water. Interestingly, the allocation ordinance talks about suppliers and things like that. They can charge for water. They can do all those things. But there's a lot of things in that they're asking you to take judicial notice of, and we're at the stage now where you should not take judicial notice of that. I'm sure you're going to hear some of the statements about things outside the record, and I understand my time is up. So
Does that answer your question, Judge Griggs? All right, then you have time on rebuttal. Thank you,
Thank
Mr.
you.
Nichols. Mr. Sheedy?
Yes, good morning. I am inclined to remove my mask, but I certainly don't want to be discourteous to the court or court personnel or anyone in the court. So if there's
You are welcome.
I'll remove.
You're welcome to remove your mask.
Just didn't want.
Thank you.
Record Jim Sheedy appearing on behalf of Franklin County, North Carolina. As opposing counsel indicated, this matter is before the court for review of a Rule 12b1 decision.
Mr. Sheedy, I'm sorry, I was going to try to wait saying this. I do not for the life of me understand how this is Rule 12b1. I think you're probably right, but this seems obviously 12b6. I guess first factual question, does your client have any problem if we were to affirm based on 12b6?
Well, my client is not going to have a problem if you affirm, Your Honor.
Fair enough.
But it is a subject matter jurisdiction claim because while the complaint may be construed in favor of the plaintiff, including all reasonable inferences to be derived therefrom, given this is subject matter not based on diversity, but based on federal question.
Right, but
The underlying federal question is a state law claim. The irreducible minimum standard has to be met. And we're here saying the lower court was correct. It hasn't been met facially from the four corners.
Here's my problem. I'm reading the district court's opinion and I'm totally with the court. I understand it. Their property interest claim is weird. It's untenable. It doesn't make a lot of sense. This is not a constitutional property interest. And I'm with you. And then we say the fact that they don't have a property interest means they don't have standing. And that to me is just wrong. That means they don't have a due process claim, not that they don't have standing to make a due process claim.
Well, they have a due process claim.
Well, the instant they have a due process claim, we have subject matter jurisdiction under federal question.
But there must be an infringement, a constitutional infringement, as, for example, was discussed in both Ross and in Gonzalez, of an underlying state law right. And because they have no property interest, and it's really not a real property or personal property interest, it's an interest in a benefit.
No, I mean, but that's right.
Interest in a benefit, it doesn't really attach. There's no infringement. You can't have an infringement if you don't first have a right.
I think I can agree with everything you just said there, other than the conclusion that that means they don't have standing. That to me is, I mean, they allege they have a property interest. Now, they may be wrong about whether they have a property interest. I'm inclined to think they are wrong about whether they have a property interest. But saying that you don't have a property interest doesn't mean you don't have federal question jurisdiction. It means that your claim, I mean, people, prisoners, lots of folks allege deprivations of property all the time, and courts find in some of those circumstances. You know, prisoners allege that they had a property interest in disciplinary proceedings, or people challenging regulatory actions allege they had a property interest. And courts find sometimes they don't have a property interest, but what they do then is say that you failed to state a claim on which relief can be granted, not that you don't have standing to make your claim.
Unique here, for example, in Gonzalez, there was a Colorado statute. And the court was looking at whether that restraining order afforded any jurisdiction to the police. Distinctive here, comparing this to Gonzalez or Roth, or even this court's decision in Beck, there is no underlying state law, common law vested right to a benefit in a water and sewer allocation. General Note 4 says, as the court quoted a moment ago, this development will be served. That is all it says. It does not say served how much. It doesn't say when. It's a mere designation of who the provider to that development is going to be. So this matter is before the court on Judge Meyer's order. And in response to the court's question, there has to be a concrete, particularized invasion of a legally protected interest. There must be some kind of connection between the injury and the conduct of the county. Both of those elements are not met here. And because those elements are not met here, the lower court felt there was no standing. Whether you use the word standing or you say there was a lack of subject matter jurisdiction, there is no subject matter jurisdiction, because unique here is it's a federal question jurisdiction that they're asserting, not diversity. They don't have diversity. They've conceded that point. So for federal question jurisdiction, based on a constitutional infringement of a state law right, they must meet this irreducible minimum standard. And those are strong words, irreducible and minimum. And it is equally strong that the first prong of that test refers to a concrete, particularized invasion. So if this matter were before the court without irreducible, without minimum, without concrete, particularized invasion, yes, it would be a different exercise for the court under 12b-6. But that's not the posture of this case.
Could you tell me how, if at all, the settlement agreement impacts the argument here?
As I understand the argument, it is a two-pronged argument. The first prong, which I think I just addressed, that under General Note 4, there is no benefit in property. The second prong, as I understand the appellant's argument, is that the settlement agreement itself created that benefit in property. And the difficulty with that argument already identified is the language that it's an application. Although they wanted 95 lots, they agreed that they could apply for only up to 50, and that's a cutback. That's not a ministerial task. That's a concession, only up to 50. And then in the future, they had to apply like any other developer. They had to submit their application. The county would review it in good faith. The county would review it in the ordinary course of business, and the county would do so in a non-discriminatory fashion. Thus, the settlement agreement itself no more creates a legally protected interest than the General Note 4 on the plan creates a legally protected interest. Continuing for a moment, there are also arguments with respect to whether there was some type of contract right springing from General Note 4 on the plan. Well, this developer acquired an interest in 2012, 7 years after this plan was approved. There is no language on that plan indicating that assignees get to stand in the shoes of their predecessor. Sure, the plan runs with the land, but I would also point out, which is in the record, that the settlement agreement itself also runs with the land. It was recorded. You can see the book and page number at the top of the settlement agreement. And therefore, there is no contract interest with respect to this that would give rise to a state law protected property interest either. The assertion is, I call it the WASO. That's my turn of phrase for that acronym. The WASO and General Note 4 are purportedly inconsistent with each other. Well, they're not really inconsistent. The county didn't withdraw or change that designation that it was going to be the utility provider to this subdivision. Note 4 says who will serve, and the water and sewer allocation ordinance provides the specific procedure by which an allocation of quantity is made to these lots. And without that, as I heard the court inquire earlier, the county doesn't know exactly what it is allocating in the way of total capacity for those lots. So the WASO didn't take anything from the appellant because the appellant didn't have any allocation of capacity before the WASO was enacted. The fact that the WASO applies after enactment when there is a request for allocation only suggests that this was the process, both substantively and procedurally, by which an allocation of a specific amount of water flow and a specific amount of sewer flow may be made to the property that is shown on this plan. County reviewed and exercised its discretion with respect to that plan in 2005. That's what the approved stamp on the plan would tend to indicate. County reviewed and exercised discretion over the applications. As I said a moment ago, they could apply for up to 50, but they couldn't have 95. And as the cases indicate, when it refers to a legally protected property interest, the word protected goes to whether the exercise of discretion is occurring, in this case, by the county. In addition to the fact, under the first prong of the three-prong irreducible minimum test, there's no injury here. These constitutional challenges are based on a potential that some future application is going to be denied.
Well, I think they would say their injury is all the money they've already expended in developing the property and the opportunity lost in further developing the property with the water and sewer they expected.
Which is a 5-month delay during COVID. What it really amounts to.
But you don't deny that at some point, I mean, if a government entity tells people you're allowed to do something and they spend I mean, I know this isn't the facts of this case, but I guess I'm just making a point. If they spend years working on it and hundreds of thousands or millions of dollars on reliance on that, at some point there are restrictions on the government's ability to say, just kidding, can't do that actually.
And under North Carolina law, if it's permits, if it's zoning, then yes, those common law vested rights exist. But as admitted in the brief of the appellant, the original brief and in the reply brief, there is no common law vested right to a water and sewer allocation. We're not saying that we're not going to serve the development, but we are saying that they do have to apply for the allocation. And they would receive an allocation for the specific number of lots that that are shown on the application, and the amount or quantity that is awarded, which again you can see from a review of the application, which is in the appendix, is times whatever the quantity is attributed to those lots at the time under Department of Environmental Quality loading requirements. So we're not saying that they can't apply. And as the court has already inquired.
What about opposing counsel's statement in the brief that the Utility Advisory Committee determined it would not and would never recommend the PEM's 2020 application be approved?
Well, I think two things. I think first, that's not borne out by the minutes of the meeting. So mention.
I agree with that.
And second, I don't see anything in the water and sewer allocation ordinance that says that this developer would never be entitled to an allocation if it applied and met the requirements of the water and sewer allocation ordinance. And as I think the pleadings indicate, because I don't want to go outside the record, this is after all a facial challenge. This developer has admitted that it's been applying for water and sewer allocations. So no, I don't think it's borne out by the documents which are before this court that the county would never consider granting an allocation to this developer. Turning to the equal protection portion of the case for a moment. As the court has already noted, there really is only one bare bones allegation with respect to equal protection under the equal protection cause of action in that complaint. In fairness, there are prior allegations in the complaint which presumably are incorporated by reference into that equal protection count. But the court is absolutely correct. There is no allegation in that complaint of anyone who applied for an allocation after the water and sewer allocation ordinance had been enacted that was granted an allocation without having to comply with the ordinance.
Well, I mean, I guess
That
arguably,
is deficient.
arguably the equal protection component says that, but it strikes me that is a conclusory statement of the legal standard, and I don't see how that satisfies Twombly and Iqbal. Right. I mean, the equal protection component asserts that people were, but it provides no facts whatsoever about who it was, when it was, what the circumstances were. And I guess to return to my earlier point that I'm not sure why this is subject matter jurisdiction, it strikes me that the answer there is that is a conclusory allegation of law that fails the standards of pleading as articulated by the Supreme Court in Twombly and Iqbal.
I don't disagree with that. Similarly,
Well, but that's not a 12B1, that's a 12B6.
similarly situated necessarily means that you have to at least in your averments put forth enough facts to meet the element that they are indeed similarly situated.
I absolutely-
think that's deficient here.
Oh, to be clear, I absolutely agree with you. That doesn't comply with Rule 8 of the Federal Rules of Civil Procedure. I'm just not sure why it's subject matter jurisdiction.
I understand. And Your Honor, in exchange with opposing counsel, asked about takings. I don't think this is a Lucas case. It's not a Lucas case because again, there's no underlying regulatory deprivation of an existing state law right. So I certainly am not surprised or disappointed that there is no federal takings claim.
Well, sure, then they'd have to allege that they've been deprived of all economically viable use of the land.
In order to comport with the holding in Lucas.
Right.
Turning to really the last tier of this, because it's sort of a three-tiered analysis of first, do they have and have they alleged a sufficient amount to meet the irreducible minimum standard? Second, on subject matter jurisdiction, do we have allegations which construed in favor of the plaintiff, including all reasonable inferences therefrom? Do we have similarly situated that have been treated disparately? We have looked at that. The lower court then dismissed the remaining state law claims for lack of supplemental jurisdiction. And I don't think there is any dispute between the appellant and the appellee based on the briefs. If there's no federal question jurisdiction over the constitutional claims, there's no supplemental jurisdiction over the state law claims. So here, there is no federal question jurisdiction over these constitutional infringements of a non-existent state law interest in a benefit to property. There is no supplemental jurisdiction either. So the position of the county, the appellee, if this case belongs in any court, it belongs in state court. That's the place to go create a common law vested right in a water and sewer allocation. Appellant contest under North Carolina law whether it has vested rights to such a benefit and whether it has some impending or imminent injury. Of course, the county believes that there is no common law vested right to an allocation of water and sewer capacity, nor is there any injury to this developer. Thank you.
All right, thank you, Mr. Sheedy. Mr. Nichols, you have some time?
Thank you. Is it 2:22 then?
No, she's resetting it to 5, sorry.
Thank you. And as this court has said in United States versus North Carolina, which we cite in our briefs, when there is a factual attack on subject matter jurisdiction that involves the merits of a dispute, because that's really what this is. A lot of the questions you're asking is, what's the practical effect of the settlement? What did you mean by this, right? What was meant by any vested rights, in which the district court, took notice of that could be a statement there were vested rights or not. We contend there were. So when there is a factual dispute, the proper course of action for the district court is to find that jurisdiction exists and deal with the objection as a direct attack on the merits of the plaintiff's case. Court should refuse to treat indirect attacks on the merit as 12B1 motions. merits and jurisdictional questions are not identical. They're so closely related to the jurisdictional issue. It's not suited for resolution in the context of a motion to dismiss for lack of subject matter jurisdiction. You're also, with respect to our seventh claim for relief, we contend that the ordinance itself, which states in part, an applicant of an additional phase of an existing subdivision must have 30% of previous allocation as homeowner account, comma, not builder account, comma, prior to any additional phases be awarded allocation. We contend that on its face, that's a violation of due process because the ordinance is so vague in that it doesn't define applicant, it doesn't define phase, doesn't define existing subdivision, doesn't define previous allocation or additional phases or builder account. We are being tied essentially to what other people who are not us do within the subdivision. So yes, they, unless they can explain that we have the same rights as everyone else, we don't in this instance because we had something. And the argument that, it's an unlimited allocation, they could charge for these services. Municipalities routinely do. They can get water and sewer from elsewhere. So with respect to the property right interest, you keep hearing about permits. That's not the test in the North Carolina state law. The test is whether or not there was a benefit. There was. And if you don't believe there was, that's a factual question. What was meant by what water and sewer will be allocated, would be provided by county? They say that just means, they said in their brief that you should take judicial notice that just means that the county would be the provider. Let's see what they said. That the county would essentially that the county, it just means the county will be the provider instead of wells and septic tanks or a community water system in a septic drain field. That's what they say. That's judicial notice that they asked the district court and asked you to take. What does that note mean? That's a factual question. And if it's a factual question, it's not appropriate to resolve on 12B1. If you look under North Carolina state law, we have alleged a property interest in a benefit. And it's an allegation that we believe can be proven, but it can't be proven if the right to conduct any discovery or to ask them any questions about what was meant is taken away. So if you have that property right and it was taken away, then we contend you still have this equal protection claim. Now I understand your position, Your Honor, that you could believe this would be more appropriate for 12B6. That is not the way the district court analyzed this matter. And so obviously we're here on the 12B1 aspect. I hear what you're saying with.
Well, but I mean, I think as a descriptive matter, we have before affirmed a dismissal that was improperly labeled under 12B1 under 12B6.
I understand, Your Honor. And I think with respect to that, I would say that we do state a claim for the violation of due process rights. We state a claim for equal protection. There is, if you look at construing and I understand your position, but if you construe the evidence in the light most favorable to us, and if you are taking the claim and you're looking at in the 12B6 scenario, the attachments, if you look at that March 20th meeting notice in comparison to everything else, you have to say that there were other developers in there that received allocations when we did not, and they are similarly situated to us. So the equal protection claim as pled, we can't establish yet at the pleading stage whether these people were actually similarly situated. That's a narrow description, as the court knows, but we can't establish that until we conduct, discovery on the case. So when it comes down to it, while they would like to say this is purely a state law case and this should be in state court, we've alleged sufficient federal court allegations and claims that should allow this case to survive. We do have standing. We would ask that the court reverse the decision of the district.
All right, thank you. And thank both of you for good arguments today. We appreciate it. And I see you're both from Charlotte. Safe travels back. Maybe y'all can ride back together. And remember to take the microphone covers off, please. All right, we're ready to hear argument in our second case, North Carolina Insurance Guarantee Association versus Becerra. Mr. Blake.
Morning, Your Honor. May it please
Morning.
the court, my name is Chris Blake of the North Carolina Bar. I'm here on behalf, today on behalf of the appellant, North Carolina Insurance Guarantee Association. The NCIGA is a statutory entity created by the North Carolina General Assembly and is intended to be a recovery source of last resort following the insolvency of certain insurance companies. The NCIGA commenced this declaratory judgment action before the district court that is the subject of this appeal, seeking a judicial declaration on a pure issue of law, whether the NCIGA is a primary plan for purposes of Medicare secondary payer reimbursements under the Medicare Act, or whether the NCIGA is an applicable plan for purposes of Section 111 reporting under the Medicare statutes. The substantive determination on this legal issue has been reached by both the Ninth and the First Circuits, and the NCIGA simply seeks an opportunity to have that legal issue decided in this circuit.
Well,
What
Mr.
about
Blake-
the Seventh Circuit
The Seventh Circuit has
in
considered-
Illinois Guarantee Fund versus Becerra?
So the Seventh Circuit considered an appeal that is postured just like our appeal is today before this court. The Seventh Circuit has not reached the substantive issue. The Seventh Circuit essentially considered the exact appeal that's before you this morning.
And they said they couldn't hear the exact appeal that we have before us.
That's correct. And we believe that the Seventh Circuit was incorrect in reaching that conclusion.
Why were they wrong?
They were wrong because what I believe the Seventh Circuit failed to do in that case was make a distinction between two aspects of the NCIGA's claim that were brought before the district court. The first part of the NCIGA's claim deals with the question of whether or not the NCIGA is obligated as a primary plan to reimburse Medicare for secondary payments that are made. The second part of the NCIGA's claim deals with the obligation to comply with Section 111 reporting requirements and the significant burdens and expenses that go along with that compliance. So the Illinois case only dealt with Section 111 reporting. The Illinois case did not involve the first part of the claim, which is, are we obligated as a primary plan to reimburse Medicare? The other thing that the Seventh Circuit did that I believe was incorrect was
Well, doesn't the NCIGA step in when an insurer is insolvent? Is that when they
That's
step in?
correct.
Well, in that instance, then don't they, in essence, stand in the shoes of the insolvent insurer, making them, okay, why not?
They do not, because under North Carolina state law, and it's a provision in the Guarantee Act, which is the governing statute for the Guarantee Association. It says there that the Guarantee Association is deemed the insurer to the extent of covered claims. Covered claims are a defined term in the governing statute. And so the North Carolina Court of Appeals decided in 1984 in a case that the Guarantee Association is not the legal successor to the insolvent insurance company. The way insurance insolvencies work under state law, when an insurance company becomes insolvent, the commissioner of insurance of the state where the company is domiciled becomes the liquidator. That is the successor to the insurance company. Guarantee associations step in to pay statutorily defined covered claims, but they are not the successor to the insurer, and they are not deemed the insurer for all purposes.
They are deemed the insurer to the extent of covered claims.
Correct.
Mr. Blake, can I take a step back? So in your complaint, you identified a whole bunch of federal statutes that created subject matter jurisdiction in this case. But on appeal, I feel like the number has narrowed. So for my purposes, can you just tell me what statutes are you claiming create federal subject matter jurisdiction in this case?
It is the Medicare statutes, because we can't bring a claim, even though we're a state created entity, we can't bring a claim against Medicare in state court.
But then the Medicare statutes say if you want to sue under the Medicare statutes, you have to do a whole series of things. So I guess let me just give you a chance to react to the supposition that you're trying to have your cake and eat it too. You're trying to sue under the Medicare statute without complying with the requirements that the Medicare statute says you have to comply with in order to sue under the Medicare statute.
And so let me try to address that question from the court, and I'll start by acknowledging that the pathway for the Guarantee Association to establish subject matter jurisdiction at this stage under the Medicare statutes, I will concede, is a narrow one, but it is not an impossible one. Okay. And the way that I see that the Guarantee Association has a pathway through that narrow exception that the courts have recognized is the following. And I point to one of the things that the government argued in its brief at page 7, where it cited to 42 CFR section 405.924B6, which says that a primary plan may seek administrative review of the amount or existence of the Medicare secondary payer recovery claim or reimbursement claim. So first part of that, are we a plan? And that's the primary argument that we're making, that we are not a primary plan consistent with the decision in the Ninth Circuit, that we're not a primary plan. And because those administrative procedures that you're referring to, Your Honor, apply only to primary plans, if we were to have to invoke those procedures, we would essentially have to concede that we were a primary plan. And that would create issues.
Well, you wouldn't have to concede. It would be if the government took the position you were a primary plan, you could then contest the government's and then did something to you, whether it tried to recoup money from you based on the assertion you were a primary plan or tried to sanction you for violating reporting requirements on the theory that you're a primary plan. Then you could resist on the grounds of, no, I did not, in fact, but so I don't understand how that helps you.
Well, but then you look at the rest of the statute that we can seek administrative review of the amount or existence of a claim.
Right. In your view would be the existence is zero.
Our complaint before the district court doesn't challenge the amount or existence of the claim. What we challenge is the first part of that is, are we a primary plan that is subject to the statutes?
Well, then I guess this gets us into the standing issue, which is that, I mean, courts don't have jurisdiction to answer abstract legal questions. I mean, I know you might like to know, but there's a lot of legal questions that I might like to know the answer to. That doesn't mean I can file a lawsuit until someone actually does or threatens to do something concrete to me based on that.
Here's why this is not an abstract question, and it goes to the question of standing and whether there was an sufficient allegation of an injury in fact. With respect to the Section 111 reporting, okay, the way the Medicare statutes work in the real world, the Section 111 reporting is how a private insurance company would report to Medicare information about payments that it made to potential Medicare beneficiaries. The insurance company makes these payments. They may not know whether the person is over 65, whether the person is disabled, but they have to report all of this data and information to Medicare. Medicare then uses that data to identify those payments for which they might want to seek reimbursement. Okay. And so the Guarantee Association complies with the Section 111 reporting because of the potential that if they don't do the reporting, they could be exposed to fines and penalties. And as a law-abiding entity created under state law.
Well, could they actually be exposed to fines and penalties right now when there is no penalty structure?
The statute provides for those penalties.
No, but I mean, in the real world right now, is there any actual risk of being exposed to fines and penalties?
I can't say that there's no risk, Your Honor.
How could the agency sanction you? There's no penalty regime right now.
The statute provides for those penalties and sanctions right now. So is there an option for the Guarantee Association to simply say?
So is your alleged injury compliance that may result in potential penalties? Is that your injury?
It's the combination of the burdens and expense, the administrative burdens and expense on the Guarantee Association to comply.
And where is that best addressed in your complaint?
It is addressed in our complaint.
Yeah, I know where. I know you said I don't know that it is. That's why I'm asking, where is that allegation in your complaint?
I don't have the complaint in front of me, Your Honor. I don't know the specific.
What is this case about? The dismissal of your complaint or not? And you don't have the complaint in front of you? Okay.
I apologize.
Okay, well, I do, so maybe I'll keep looking for that.
We alleged in our complaint that we incur the administrative burdens of complying with Section 111 reporting. And that allegation, we believe, is sufficient in light of the decision of this court in the Chambers case, which is the case decided by this court where it was alleged that the plaintiff was incurring costs to monitor the laws of other states to avoid violation of a blacklisting provision. It's also consistent with the allegations that this court found in the Liberty University case in lieu, in which Liberty University plausibly alleged that it may well incur additional costs because of the administrative burden of assuring compliance with the employer mandate under the Affordable Care Act. The government in this case doesn't deny that the NCIGA complies with Section 111 and does not dispute in its brief that the NCIGA has incurred and will continue to incur costs associated with Section 111. The only argument is that somehow the allegations were insufficient, which we believe is inconsistent with this court's decisions in Chambers and lieu that found similar allegations of incurring costs and burdens to comply with federal statutes were sufficient to allege an injury in fact.
And
then-
Mr. Blake,
Yes,
and
Judge.
just putting aside the standing issue for a moment, let's say you have standing, again, how do we get jurisdiction given the language in the statute? Where's the final decision from the agency? How does your claim circumvent the issue under Section 405?
Here's, I believe it can do it in two ways, Your Honor. We cited in our case the decision of the Supreme Court in Bowen v. Michigan Academy, which is one of the cases that recognized that there is this narrow exception to the requirement, the channeling requirement that all disputes under the Medicare statute have to go through the agency. In that case, there was a challenge to calculating benefits under Medicare Part B. And at the time that action was brought, there was no avenue through the administrative appeals for challenging regulations, calculations under Part B, only a pathway to challenge calculations under Part A. And in that case, the court said that because there was no avenue for administrative appeal, that claim could proceed. Similarly here, under Section 111, there currently, and the government doesn't dispute this, there currently is no appeal process under which somebody can challenge Section 111 reporting requirements. What the Seventh Circuit decided in the—
Well, there's no way to challenge it because there's no way for the government to sanction you for not doing it.
The statute, Your Honor, even though they have a current rulemaking concerning when those fines and penalties might be imposed, the statute currently does have provisions that provide for fines and penalties for noncompliance. And in the face of those statutory provisions, you leave my client, potentially leaving my client faced with a Hobbesian choice: either continue to comply, continue to incur, or necessarily expose yourself to the potential for the risk of noncompliance. And the government, I believe, Your Honor, I would submit to you, it is an unlikely scenario that if we suddenly stop complying and simply stop submitting the reports, that we're never going to hear from the government, because those reports are how the government identifies these potential secondary payments to begin with.
Well, okay, so on this issue of 405H, is there any, I guess what I'll say is, I mean, I'm just looking at the statute right now. So you've told me that this case, I guess I asked you, where does subject matter jurisdiction come from? You said the Medicare statute, which means this is a claim arising under the Medicare statute. And then in H, it says no action against the United States, the Commissioner of Social Security, or any officer or employer thereof shall be brought under Section 1331 or 1346 to recover on any claim arising under this subchapter. So that says you can't sue under any if once your claim arises under Medicare, you can't sue under any statute other than this statute. And this statute tells you you have certain preconditions to sue under this statute, which we concede you don't meet. So I'm just not sure how we do this.
And it's because the Supreme Court has recognized this narrow exception that I cited to in the Bowen versus Michigan Academy case.
Sure.
Where there is no avenue for appeal, then they allow for the claim to come directly to federal court.
Okay, so that
For Section 111, there is no avenue for appeal. If we want to raise a challenge that we're not obligated to comply with Section 111, there's no way for us to come to the Medicare appeal process and challenge
But
that.
I guess this circles back to my original point. Like, there isn't subject matter jurisdiction just because you want to raise a challenge. There's subject matter jurisdiction, if it exists at all, to raise concrete legal claims. I guess I know we're running low on your opening argument. Is there any other choice in order to rule for you on that point? Is there anything we could do other than simply saying the Seventh Circuit is dead wrong? I mean, is there any material way in which your claim is different than the one the Seventh Circuit rejected?
The material way is the second part of addressing the 405H exception, which goes to the first part of the Guarantee Association's claim, which challenges the right to seek reimbursement of the secondary payer reimbursement. And we cited to the decision of the DC Circuit and Council for Urological Interests, in which in that case, the DC Circuit considered the failure to provide administrative remedies for non-Medicare providers. There was the way that case was situated. There was a party who wanted to challenge something, right? There was a pathway through the appeal process for doing it, but the court considered that what do we do when there's an avenue for administrative review of a particular claim, but not, quote, by the category of affected parties who wish to bring the claim. And we look at that case and cite that case as support for our position that we are in the same position as that party. We are not, as a state insurance guarantee association, we are not in the category of primary plans that's obligated to reimburse Medicare. And that case allowed that party to bring that action in federal court, notwithstanding 405H. And we believe we fit within that decision, and our claim should have been allowed to proceed.
All right, thank you. You have some time on rebuttal, Mr. Blake. Mr. Fowler?
Thank you, Your Honors. My name is Ben Fowler. I represent the interests of the United States in this matter. As the court's questions have already indicated, there are two primary issues here. The first issue is whether the district court correctly decided the NCIGA did not have standing because they had not properly alleged their injury. The second issue, and the stronger argument I will tell you, is that the district court correctly decided the Medicare Act precludes federal question jurisdiction because there's no statutory basis for the relief they seek. As the court's aware, there must be channeling, exhaustion. There is an avenue for appeal here in this case. The cases cited by the appellants here are not applicable here because in those cases, there was not an avenue for appeal. Here, there clearly is a four-level avenue of appeal, and we in fact footnoted that there are already ongoing. It's not part of the record, but just so you know, it's not just theoretical. There actually are avenues of appeal to pay the amount conditionally and then challenge whether or not they can do this.
Well, there certainly are avenues of appeal to the extent that you ask them for money. And it seems that there's clearly avenues to appeal to the extent you ask them for money. But what about their claim of the interim effect of not even knowing, right? So they basically say, look, Medicare refuses to tell us whether they think we're covered or not. If we're covered, we have to submit these reports. And if we don't submit these reports, bad things can happen to us under the statute, which means that we're doing what any rational business would do. We're expending money to comply with those reporting obligations, which we don't think we have to do, but Medicare refused. What is their avenue for challenging the sort of interim effect of Medicare's refusal to give them a straight answer about whether Medicare thinks they're covered?
There is an answer coming, Your Honor. The first level appeal, they pay the amount conditionally.
No. I'm not talking about Medicare sends them a bill. I'm talking about in the period where they don't know if Medicare is ever going to send them a bill. How can they challenge that?
Well, the Medicare statute, Your Honor, does not allow them to challenge things theoretically. Your questions already went to that point. They cannot challenge that just because they're curious because they want to know the interim.
Say that I'm the general counsel to a company, and it says, look, if we are a primary plan, we are required to submit these reports to Medicare. And if we are a primary plan and we don't submit these reports to Medicare, bad things can happen to us. So it's a really important thing to figure out whether, and of course, submitting these reports isn't free. It's going to cost money to submit these reports. And so the council says, I don't know, should we submit the reports? And the lawyer says, well, I don't think you're actually a primary plan. Unfortunately, there's no way to definitively find out if you are a primary plan. So I guess we just need to err on the side of caution and expend hundreds of thousands of dollars to submit these reports because there's no way for us to figure out what is that company. What am I getting wrong as the general counsel of that hypothetical company?
I don't know that you're getting anything wrong regarding giving them advice about their best course of conduct. The issue for the court, though, respectfully, Your Honor, is whether they have jurisdiction to bring this case. But I completely understand their interest in getting an answer to this. There's a pathway for them to getting an answer. They have to allege it in the complaint, which they haven't done. There's not a standing.
Allege what? What do they have to allege?
The actual injury, what the reporting. Initially, Your Honor, they argued that there were penalties. There are not penalties. There have not been penalties. There will not be.
They allege
penalties.
there are burdens and expenses. I think that's what he says, burdens and
Right.
expenses. I don't know what it's attached to, but
Exactly, Your Honor. That was what the complaint says. All they say is just the magic words, burdens, and expenses without fleshing that out. In theory, if they flesh that out enough, there might be an injury in fact, but they have not done so. The district court correctly found that just saying burdens and expenses is not enough.
Okay, so but assume they did that. Assume they plead lots and lots and lots. And here's an itemized list of all the expenses, and here's why we did it. And here's a signed affidavit from the CEO saying the only reason we do this is because we think that Medicare might drop the hammer on us if we don't, and we would stop immediately. Your view would still be that we wouldn't have subject matter jurisdiction to hear that claim.
Absolutely. The standing argument in theory could be cured if they did it properly. They have not. The district court was correct in that, but they cannot cure the jurisdictional argument, Your Honor, because they have to channel it. They have to exhaust it. There has to be a final decision by the MAC, the Medicare Appeals Council. That is a secretary's decision. They talk about what has been conceded and what's been done. All of that is at the preliminary levels. The MAC makes the decision. MAC, the Medicare Appeals Council, makes the decision for the secretary. That decision has not been made. We don't know what that decision will be. In the cases that they've relied upon where they say there's already been a decision, it was totally a different structure.
So as I said to your friend on the other side, I agree with you that the language of the statute, the jurisdiction language is sweeping. It's absolutely sweeping. But your friend on the other side is right that the Supreme Court seems to have said, well, the language is really sweeping, but under certain circumstances, the language doesn't necessarily mean exactly what it says.
Where there's not an appeal right.
Right.
Those cases are all where there's not an avenue for appeal. Here, there is an avenue for appeal.
Well, an avenue appeal, I think part of the problem we're having is an avenue appeal of what? I mean, I agree with you that so if to the extent you send them a bill, there is an appeal right. Totally agree with that. But to the extent they just say, that hypo again, the general counsel, to the extent they just say like, no, the thing I don't know is whether I'm covered and no one will give me an answer and there's no way to find out. What is their avenue for appeal there?
There's a conditional payment and they rate.
No. Medicare has not sent them a bill. The whole point is that Medicare hasn't sent them a bill, so they don't know if they have to report or not.
I'm not addressing the penalty question, but there's a payment. If there is a secondary payer situation,
Right.
where your insurance company, underlying insurance company has gone bankrupt and you're making those payments, at that point, you're obligated to also make the payment. You make that payment conditionally and you challenge it up to 4 levels that we've talked about, Your Honor. That, in fact, has happened. That has happened. Footnote 6, Your Honor. They can pay that and make a conditional payment and argue that and take that up. Part and parcel for that payment is we also challenge.
Footnote 6 of what? I'm sorry.
Of our brief, Your Honor. My apologies. We specifically note that there have been some first level, and there's actually been one all the way to the ALJ level where they've raised this issue.
another party, you mean, not this?
No.
This
NCIGA has raised it, Your Honor.
Okay.
Counsel opposite from me has made that
Was
argument.
that put before the district court?
It was not before the district court. I bring it to your attention as an example where they can seek administrative review. And we footnoted it, but it's not part of the record, Your Honor. But it's not just theoretical. It actually is an appeal possibility for them up to through the levels. And if they do that, they'll get a MAC decision. And at that point, they do get their ticket to district court and they can challenge it. So that defeats all of their jurisdictional arguments. There's an exception here. If they have a possibility.
And so your view is that under that appeal, they can say, your friend on the other side quotes the regulation that says a primary plan can challenge either the amount or any payment. So you think it would be open to them during that appeal to say, the amount of the required payment is zero, because under a proper construction of the Medicare statute, we are not a primary plan, and so the number is zero.
Absolutely. Part and parcel of their conditional payment can be a challenge to whether they're a primary plan or an applicable plan. And there's not a distinction there as far as the reporting requirement and theoretical.
And is there some preclusive effect? So say they get a bill, again, I'm simplifying a lot. Say they get a bill for Medicare, and they challenge it. And they challenge it on the grounds, I am not a primary plan. And in that adjudication, challenging that one particular payment, there is a conclusion within the agency that they are not a primary plan. Does that have some sort of preclusive effect? Like once someone within the agency were to tell them you're not a primary plan, can they go forth and rely on the assumption that they're not a primary plan?
Not the first person, Your Honor.
Sure.
It has to be the 401.
I imagine if the government loses that, they might appeal it to somebody else.
The MAC says that's the decision of the secretary. At that point, that becomes preclusive for not just NCIGA, but it would be a larger issue. As you know, we don't challenge the one in California, the SIGA case, because in that case, there was no appeal right. That happened before the regulations were in place where they could appeal it. So that is an exception for them because of the unique timing of that. However, since then, in fact, within months of that, there was an appeal right where they can challenge this. There's not been a final decision for NCIGA.
Mr. Fowler, I understand that the administrative appeal that you talk about in footnote 6 that you directed us to is not a part of the record, but couldn't we take judicial notice of that? It's an administrative appeal.
And I checked this week, it's not published yet, but there is an ALJ decision that will be published, we believe, at some point that specifically addressed the issues raised and specifically referenced this litigation.
But the appeal that being taken at all would be, we could take judicial notice of that.
Yes, Your Honor.
Mhm.
So it's not theoretical. They can, in fact, take an appeal. Once they go through that process, they will get a final decision, and that would be appealable. Channeling only requires that you exhaust administrative remedies. It's not precluding they're getting a judicial review. I mean, the secretary will make a decision. The secretary will have a decision that's appealable to a district court, and at that point, they establish jurisdiction. And at that point, the court certainly could review that decision, but it's premature at this point. The whole point of channeling and all the requirements of the case law and the statute is to create an orderly system so that the secretary can properly make these decisions instead of every provider, every entity in the country asking for theoretical answers. As you said, Your Honor, you can't have your cake and eat it too. You know, if they're asking the question, they've got to wait. You can't have it both ways. They have asked the question. There is an appeal process. They have to wait for that decision and take it through the channels in order to get their ticket to district court and jurisdiction, Your Honor.
What is the status of this seemingly interminable rulemaking?
I wish I knew, Your Honor.
What's the last thing that happened?
The penalty regulations are still in process. I don't have any anything that I can provide for Your Honor. But the key to that is they have stated, and it's very clear in the briefs, and we can't change from that position, that there will not be penalties until there's a final rule. So there's no danger of penalty. The only potential injury here is the administrative burden of filing these reports. So there's no penalty issue. And you know, that's unfortunately the situation, Your Honor.
Thank you.
Thank you.
All right. Mr. Blake, you have 3 minutes.
And I misspoke. You have a copy of the complaint?
Okay, good. So where is your injury in fact best addressed?
It is addressed in paragraph 39 of our complaint.
All right, and in paragraph 39, I found that as well. Paragraph 39 doesn't say anything about compliance.
Well, it references that
It does reference burdens and expenses.
contemplated. Those burdens and expenses, Your Honor, are those associated with the Section 111 reporting. And if for some reason that allegation was insufficient.
And that relates back to paragraph 38, the Section 111 reporting.
Yes, Your Honor.
All right.
And I would submit that if that allegation was deemed somehow insufficient, the more appropriate remedy for the district court, if that was the concern and that was the basis of the dismissal, was to grant us leave to amend, which we would have added. We could have expanded upon that, but we didn't think it was necessary, and we submit that it is sufficient.
Did you seek leave to amend?
No, we didn't, Your Honor. We filed the complaint, they filed a motion to dismiss, it was briefed, and it was decided by the court.
I know, but if you thought you could allege new facts that would have satisfied the district court, why didn't you seek leave to amend?
The district court's decision had been made, Your Honor. We would have had to file a motion for reconsideration of some kind, and we did not do that.
Could I ask you about a question that came up with your friend on the other side? So this question about how you could challenge this, I had been meaning to ask you about this statement on pages 15 to 16 of your brief, where you say, rather, the government's position is simply that the claims must be channeled through the administrative review process in connection with the dispute over a specific reimbursement request. This is the language that I want to highlight. The government is well aware that such requests have and will continue to be made. Doesn't that just concede you would have a way of challenging this? You have represented to us in your brief that the government has requested reimbursement. If they've requested reimbursement, you can challenge it under the Medicare statute and then get judicial review of that.
But Your Honor, this, the government calls this a circular argument, and it circles back, I believe, against them. Notwithstanding the request for reimbursement, our issue, as stated in our complaint, goes back to the very first part of the statute. Are we a primary plan?
Right. And you could say the reason that I don't have to pay this reimbursement request is because I am not a primary plan.
And we argue elsewhere in our brief when we get into the exhaustion of remedies and the exceptions to exhaustion of remedies, that legal issue, whether we're a primary plan, I can stand before you today and say with 100% certainty, we know what the outcome of the appeal process is.
Great. And then you can seek judicial review of that final decision of the agency.
And we submit that based upon the cases we cited, we shouldn't have to.
No, but those are cases about where there is no way to get the decision of the agency, not that you anticipate you won't like the decision of the agency. Those are cases that say, and the DC Circuit's decision makes a lot of sense. Like, look, the whole premise of saying you have to present the claim to the agency presupposes there is a way to present the claim to the agency. If there is literally no way to present the claim to the agency, you don't have to. But you can't get around exhaustion just by saying, well, it's going to be annoying and I feel like I already know what they're going to say anyway, so I don't have to.
Well, there's two ways, Your Honor. One, I would say that this court has recognized that issues of statutory construction could be an exception to exhaustion. This case and the claim about whether we're a primary plan or an applicable plan is a matter of statutory construction. Finally, if you'll just, I know I'm out of time, but just bear with me. Listen to what my colleague said about why the California case was different. The California case was different, he says, because at the time, there was no appeal process for challenging the secondary payment request by the government. With respect to Section 111 reporting, we are in the exact same position in this case. There is no appeal process. That rulemaking is not complete.
All right, thank you, Mr. Blake.
Thank you.
And thank both of you for your good arguments today. They were illuminating and we appreciate it. I see you all are both from Raleigh, so we have another set of potential carpoolers. Safe travels. We're going to take a 5-minute recess. Thank you. Before we'll take a brief recess.
of the United States Court of Appeals for the Fourth Circuit.
All right, thank you. You may be seated, and we're ready to hear argument in our third consolidated cases, United States versus Mack and Blades. Ms. Arbro, when you're ready.
May it please the court. My name is Kimberly Albro, and I'm here on behalf of the appellant Craig Blades. Mr. Blades' position is the South Carolina assault and battery second degree and criminal domestic violence, or CDV second degree, are not crimes of violence following the Supreme Court's Borden case, because only a reckless mens rea is required for conviction. South Carolina law makes it clear that this offense can be committed recklessly. And I would point first to the case law.
So Ms. Albro, you've probably seen this. The South Carolina Supreme Court has accepted certification on literally this question. So ultimately they're going to give us an answer. Can I ask you about something different then? Let's assume that they're going to say, yes, it is. Because if they say no, great, it's great for you. Well, there's a second question. Even if they say no, why isn't there a pretty strong harmless error argument in this case? I mean, here we have a district court saying on the record, even if I'm wrong about how to classify this offense, I would still give him this sentence. So let's assume for the sake of argument that the South Carolina Supreme Court adopts the interpretation of the statute that favors your client. Why doesn't he lose under harmless error?
Well, I have a few reasons to point to. I would agree with you. That is on the record. But you may have noticed in the joint appendix that the court came back 2 different times after that first sentencing to clarify issues. So at the first sentencing, there was an issue about the judge repeatedly referring to 120 months being the low end of the guideline range. And counsel objected, saying, you understand that 120 months is the guideline range. And I guess upon reflection, that same afternoon, the court went back into session and the sentence was clarified, and the court referenced Mr. Blades' adverse childhood experiences and said she had considered those, she had sympathy for him, and she said that she would still impose 120 months, that she understood that 120 to 150 months was the guideline range capped by the statutory maximum. But at that time, she did not again say she would impose the same sentence. So I think because of the confusion at the first hearing and the need for 2 follow-up clarification hearings, that there isn't the kind of certainty that Savignon-Matute would require to satisfy the first prong of harmless error. And second of all, under the second prong of Savignon-Matute, even though you would not get to that if you find that it's not certain that the court would impose the same sentence, there's a difference of 28 months. I think that's pretty significant under Rosales-Morales and some of the other Supreme Court rulings, that that's a significant enough that it may not be a reasonable sentence, especially in light of the adverse childhood experiences and how the judge referenced those and perhaps didn't fully consider those even in the 2 hearings clarifying.
So to just summarize, the first order argument is that we can't really be sure the court meant that because there was confusion. I mean, did anyone ask, did you ask the court to, well, I don't know if it was, did you, in the sense of your client, ask the court to clarify that?
The questions at the first sentencing hearing, the original one, was that, hey, this isn't, that's not the minimum range. That's not the minimum
right
range. So I think because of what was brought up there, it wasn't totally clarified then, even though Mr. Blades did ask for some clarification or wanted assurances that the court understood that the guideline range was not 120 to 150 months because it was capped by the statutory maximum of 120 months. So that was the guideline range.
But is there any indication, I understand the district court came back later and had to clear up the record about its apprehension about what the guidelines range had been. The court misspoke, and commendably, it, when pointed out that was a mistake, it cleared up the record. Did the court, but I guess I didn't read the transcript as indicating anything about the court walking back its previous statement. No matter how this is classified, he's getting 120 months. I didn't see anything in the transcript of the second hearing that suggests the court was walking that statement back at all.
No, I would agree that the court did not walk back that statement, but it also didn't reaffirm that statement. And it made a statement, I believe it was at that afternoon hearing, the second hearing, where it said, well, he's gotten the benefit of, of the guideline range being capped at the statutory maximum. And I think that the fact that it seemed the court was still considering the 120 to the 150 months as the guideline range in that respect, that it is not clear that if the guideline range was 92 to 115 months, the court might reconsider that, particularly because of the emphasis in the first hearing about I'm giving him the low end of the guideline range. There's no indication that she would not consider the low end of the guideline range if it became 92 to 115 months. And since we do have the certified question, if there aren't any questions about the mens rea issue, the harmless error was the only other issue that I was prepared to address unless the court has questions. Okay.
All right, no, thank you. Thank you. We'll hear from Mr. Anderson.
Good morning, Your Honors. Howard Anderson, appointed on behalf of Mr. Mack. As Your Honors, I know the case is consolidated, and my client's in a bit of a weird position in that we've got the certified question in Clemens that would be highly relevant to this court's decision, but my guy is going to get out in March.
Can you walk me through that? I tried to figure out why your guy's going to get out in March, and I'm just curious. I was based on the sentence that it was imposed. I was surprised to learn that at least your view is that your guy's going to get out in March.
Well, that's what the VOP website says.
Great. Okay.
So obviously, I'm not going to say that he should serve any longer. I think part of it is because it took a long time at the trial court that the objection was made, and then the court recessed to have the ruling. It could also be because of the First Step Act, sort of earned time credits, possibly.
Okay, sure.
I just don't know. But he's just in a weird spot that ideally I would like to know what the Supreme Court says. But if we wait that long, it's going to mean that he.
Sure. So let's talk about then why this is different than Blades, which is to say your client was convicted of a crime that contains the words offers or attempts. That sounds like mens rea to me. And it sounds like mens rea above reckless. I don't know how I recklessly offer or recklessly attempt to do something.
First, as I note, I don't necessarily agree that an offer is a threat, and to be a crime of violence, an offer has to be a threat.
Sure. No, separate question about whether it's a threat, but I guess would you agree with my intuition that it's hard to imagine that I can recklessly offer or attempt to do something?
No, Judge, I don't think that I would. Well, first you have to offer or attempt an injury, and I don't agree.
No, I get before we get to injury, there's just the first order question of what, because these cases have told us one thing we have to look at is what is the mens rea, and the court has said recklessness is not enough, knowledge and purpose is enough, and there's this extreme recklessness gray area. I guess, can I recklessly offer or attempt to do something? I know we're bracketing the something, and I promise we'll get to the something. But before we get to the something, is it possible to recklessly offer or attempt to do something?
Well, I mean, if we go to one of the hypothetical, I guess the examples that I give in my brief back during the COVID craziness, right, where you're coughing while everyone isn't sure exactly sort of what's going on. You're not necessarily intentionally trying to give someone COVID. You may not even know that other people are around, but you're not wearing your mask like you're supposed to. Again, that might be sort of a negligent.
Yeah, that might be a terrible thing to do. It might be a reckless thing to do, but I don't see how that's I don't see how coughing on someone when I should be wearing a mask is an attempt to injure them. It might be negligent, it might be reckless, but it doesn't strike me as an attempt, and it's certainly not an offer. I don't even, in that COVID hypothetical, I don't even know what an offer is. I guess I offer to sneeze on someone when I have COVID, but I don't see how that's still reckless. I mean, do you see what I'm saying?
I would agree that you cannot negligently or recklessly attempt something, because an attempt is a specific intent crime.
And how can I recklessly offer something?
And so again, this is sort of what exactly is an offer. I mean, if an offer is not just a threat, but merely a proposal to do something, right? You might, in South Carolina, conspiracy's got to have two people. It's got a much lower penalty than under federal law. But I imagine, for example, if there were someone in the other room that we were planning, that you and I were talking about killing, I didn't know the microphone was on, right? A judge, would you like for me to kill him, right? I'm willing to kill him if you want me to, right? That's an offer, or I'm willing to shoot him in the leg.
And
The
presumably,
phone is on. I don't know that it's on, right? But he hears it. It is a means that is sort of, I'm proposing to shoot you in the leg, right? So I am negligently scaring him over there, because the assault is about the fear that the victim has. The battery is about the actual touching. And so I would say that in that admittedly strained hypothetical, that you might be able to get there.
okay. So let's talk about the something then, and your argument why this doesn't require the type of force necessary to satisfy ACCA.
Yes, Judge. And so again, it has to be an injury. So the first part is you have to offer or attempt to injure. It's not necessarily you have to offer or attempt serious injury, right? I think that the injury there, as you saw from all those news articles, that we literally were prosecuting people for coughing on people.
Well, no, we saw that Iowa prosecuted one person for coughing on a person under a statute that is not the South Carolina law. And then I see a footnote in your reply brief about someone charged with third-degree A and B, whereas your client was charged with first-degree A and B.
But all of the A and Bs require an injury. And so that is a common term, whether it's first, second, third. And so it's the same, if it's the same injury for third, it's the same injury for one. And so then we also look at, and then was there serious bodily harm that resulted, yes or no? But again, if a coughing injury suffices for third, it would satisfy that.
Doesn't first-degree assault and battery require great bodily harm?
It requires an offer or attempt to injure a person, and then the act is accomplished by means likely to produce death or great bodily injury.
Sure. Okay.
So
maybe COVID is an injury, but what's your evidence that coughing on someone is likely to cause death or great bodily harm as construed by South Carolina courts?
Well, again, Judge, I am positing the hypothetical about how we get sort of coughing goes from a third to a first. And so if we have a highly communicable disease, or whether it's spitting on someone or coughing on someone, and if the disease is particularly fatal, then I could see a solicitor very well charging that if the injury actually results. So again, part of it is obviously a difficulties of proof about proving that my cough led to you getting this disease or not. But do I think that the solicitor might charge it? It wouldn't surprise me. And as I said, there have been a couple of cases involving relatively minor injuries that were actually being prosecuted. The only other, I see that my time here is almost up. The only other bit that I would point out here is that just on the degree to which the judge explained his sentence, the government's opposition was predicated upon it being plain error. If in fact, as the record shows, that a trial counsel asked for a lower sentence, they don't contest, or in their brief, they did not contest it. And so I would just point that out. And with that, Your Honors, I will serve the remainder of my time. Thank you.
Thank you. All right, Mr. Schumite?
Yes, Your Honor. May it please the court, I'm Assistant U.S. Attorney Derek Schumake, and Your Honor, for logistical purposes, on behalf of the government, I will be arguing assault and battery first and second degree being crimes of violence, and the remainder of Mr. Mack's case. My associate, Stoughton, will be arguing the remainder of Mr. So, Your Honor, as an initial matter, we believe the district courts in both cases correctly determined assault and battery first degree and second degree were crimes of violence. I understand from Your Honor's questions, we have a certified question on assault and battery second degree. I would briefly like to touch on some of the points raised as to assault and battery first degree. In this case, we are limited to the specific subsection.
So can we decide this case without South Carolina weighing in on assault and battery second degree?
I think you can, Your Honor. I think if the court came in and said it was a mens rea of an intentional act, I think it helps us greatly. But I think you can decide it without that, because even if they were to decide reckless, what's unique, as Judge Heitens pointed out, is here we're dealing with a statute or the provision of a statute that specifically deals with offers or attempts to injure. There's been some discussion about offering. I think if we look to the Drummond case, we see that they say that an offer is at least a threat, not synonymous with a threat. And so I think that the way to contextualize it is, if I tell my daughter if she doesn't do something, she's going to get her phone taken away, that's a threat. If she doesn't do the thing and I say, now I'm taking your phone, I've elevated it to an offer. And in that example, an offer still requires.
How is that I'm sorry, how is that an offer?
So in the
That's carrying out a threat.
well, I think it's not carried out yet. You're in that weird gray area between when the threat occurs and when you've done the act. So, and the case law shows that when you talk about an offer, it is a declaration of present intent to do harm. And I think that's what makes an offer an intentional act. I would call it a threat plus. It's a threat, not in the future. It's a moment. It's saying in the moment, I'm going to do this now. And Your Honor, I think again, the Drummond case, I do think answers this fairly squarely, where it dealt with the word offer to say that it is at least. And so, Your Honor, I do believe these are intentional acts.
Has the government come across cases that were actually prosecuted as offers? I'm just trying to envision like what this crime even looks like.
Your Honor, I have not found any cases, not to say that they are not out there. I do think in State versus McGowan, the court talks about attempt, but when it talks about the crime in sort of a 10,000-foot view, it conflates the offer and attempt. I think in many instances, attempts will always have an offer. And I think that most cases that you find have risen past just the offer. So I think the reason you may not find cases is because those things being prosecuted are being prosecuted as attempts, which inherently encompasses an offer. The McGowan case is an example. That person knew these people were inside, chose to get the gun, shot the gun. I think his act of getting the gun, being prepared to shoot, may be the offer. Once he fires the gun, it becomes the attempt. But in that case, and the critical issue in that case, as the court said, that person still had to have a specific intent to harm the people inside. And Your Honor, that intent, of course, is applied to the force. And the force in this case, as Your Honor has pointed out, is great bodily injury. And when we look at the statutory definition of that, we're talking about a substantial quantum of force, far more than the Chris Johnson standard of causing some type of physical pain. So, Your Honor, as to assault and battery first degree, I do believe that the case law in point indicates that you have a mens rea of greater than recklessness, and that mens rea of greater than recklessness is applied to that quantum of force, which is great bodily injury. And Your Honors, the next point in our brief that is raised by Mr. Mack is whether or not the district court erred in imposing the sentence. Your Honor, we argue plain error given the waiver. I understand there was a discussion about a lower sentence, but either way, Your Honor, even under the more deferential or less deferential abusive discretion standard, we think the court plainly justified its sentence. You had a case here that involved a fully contested hearing. Mr. Mack took the stand, his victim took the stand. I believe some people who were at the club that night took the stand. Court had a day-long hearing, had briefing, and then came back for a second hearing on a second day. An extremely rare occurrence in a supervised release case. And so, Your Honor, not only do you have the court statements, which the court specifically says in the statement that it considered, that it specifically considered the history and characteristics, employment and family strain, and policy statements. And that is merited out by the fact that the court heard information from all that. So, Your Honor, we do believe that Mr. Mack's sentence was reasonable and that the district court did not procedurally err. And Your Honor, our last argument is that even if the court did err, that error would be harmless. I do understand and fully acknowledge that the government in its brief asked the court to declare the sentence would be imposed regardless. The court did not do that. It was silent on that fact. But the court did specifically talk about knowing the difference between grade A and B, and then saying, nonetheless, this is extremely serious conduct. Mr. Mack was someone who nearly beat a man to death and then lied on the stand about it, as the court noted. It was a very...
That's certainly an argument that the court could have imposed the sentence either way. I mean, I just think this court has made pretty clear that we'll take it very seriously if a district court says I would impose the same sentence. And I guess the district court not saying it would do it doesn't prove that it wouldn't, but I guess it seems hard to not take into account the fact that the government specifically asked the district court to say, I would give him the same sentence anyway, and this district court did not say that.
It is admittedly a more different argument than Blades, where the court expressly said it. I do not contest that, Your Honor, but the court also did not expressly reject it. And did.
Sure, so maybe it would, maybe, I guess that leads me to the conclusion, maybe the judge would have, maybe the judge wouldn't have.
And I fully concede it's a tougher issue, Your Honor. We do believe the record in total supports that the judge said that was an appropriate sentence regardless of the grade. I do take your point. I do not disagree with you. Your Honor, if there are no more questions, that's all I have on this issue.
All right, thank you. We'll hear from Ms. Stone.
May it please the court, Katie Stoughton on behalf of the United States. Mr. Blades' sentence was both procedurally and substantively reasonable, and it should be affirmed. I'm happy to address the merits of the CDB issue on the merits, but given the certification issue, and as we've argued in our brief, regardless of whether either or both of Mr. Blades' predicates were properly classified as crimes of violence, any error in calculating the guideline range was clearly harmless under this court's assumed error harmlessness standard.
Just one clarification before we get to harmless error. So the government agrees he needs both of these predicates, right? If he knocks out either predicate, he's not a career offender. Is that right?
So it's actually not a career offender issue.
Sorry, but for purposes of the relevant enhancement, he only needs to knock out one of these two.
If he knocks out one of the two, his guidelines would become driven by the attempted murder cross-reference. So his guidelines would drop to 92 to 115.
So the reason we don't need to address CDB is because if he wins the second degree A and B, it doesn't matter whether he wins CDB.
Right. And if he wins both, it doesn't make a difference. The guidelines still would be 92 to 115 months.
Got it. Okay. So thank you.
So first, the court abundantly made clear that it determined 120 months was the appropriate sentence for Mr. Blade. It explicitly said repeatedly on the record that it would have varied, well, excuse me, it said once on the record that it would have varied upward to 120 months. And then it said repeatedly after that 120 months was sufficient but not greater than necessary to achieve the purposes of sentencing. In terms of the court's comments at the second and third sentencing hearings, at JA 98, the court came back on the record and said it understood that 120 months was the statutory max, that became the guideline range. And then at JA 99, it reiterated that based on the serious nature of the offense, the need to protect the public, the need for deterrence, and the other 3553A factors, any sentence below 120 months would have been insufficient. At JA 100, it again reaffirmed its commitment to a sentence of 120 months. And then at the third sentencing hearing, which was on JA 104, the district court reiterated that Mr. Blade's arguments in mitigation did not support a sentence less than the 120-month statutory max. So although the explicit assumed error harmlessness statement only came at the first hearing, the district court repeatedly emphasized after making that initial statement that it was committed to a 120-month sentence. So on the first prong of assumed error harmlessness, the court can be sufficiently confident that the district court determined 120 months would be the appropriate sentence, even if the guidelines calculation were lower. On the second prong of assumed error harmlessness, 120-month sentence was substantively reasonable. It would be just a 5-month upward variance from the high end of the guideline range of 92 to 115 months. And the district court—
It would be a 5-month variance upward, even under the most favorable guideline range to him.
Yeah, a 5-month upward variance from the
top, right? Sure.
So the district court determined that 120 months was sufficient, but not greater than necessary to achieve the purposes of sentencing after a thorough and individualized consideration of all of the 3553A factors. Mr. Blades argues in his brief that the district court based its sentence on the fact that he had only received lighter sentences in the past. And I disagree that that is what the district court based its sentence on. As I said earlier, it explicitly considered on the record the nature and circumstances of the offense, Mr. Blades' history and characteristics, of which, of course, part is his criminal history and his prior sentences. The needs to provide adequate deterrence, protect the public, and avoid unwarranted sentencing disparities, and Mr. Blades' acceptance of responsibility. It came back on the record twice more and said, this is the sentence that I think is sufficient, but not greater than necessary. So essentially, the only argument that Mr. Blades has made challenging the substantive reasonableness of the sentence is just a disagreement with the district court about how it should have weighed his prior sentences. The district court was required to consider and address that argument, and it did both of those things. The court was not required to accept that argument. It didn't. It explained why it didn't. And then it explained why, in light of all the 3553A factors, 120 months was a sufficient sentence. So, as I said, the district court sentence, even if it erred in determining one or both of these predicates was a crime of violence, was both procedurally and substantively reasonable. And the government would request the judgment be affirmed. The court has no further questions. I'm happy to rest on the brief.
Thank you.
Thank you.
All right, Ms. Albro, you have 3 minutes in rebuttal, if you'd like to use it.
Thank you, Your Honor. I don't think I need 3 minutes, but I would briefly say, since we focus solely on the harmless error issue, that
And you can remove your mask if you'd like. You don't have to.
apology, I was forgot about the mask. So I would say that at the initial sentencing hearing and the confusion that was involved there, the court did focus on the nature of the offense, but the court also focused on his character, Mr. Blade's characteristics, in that he had a very, very horrible childhood. And she said she did consider those things in choosing the low end of the guideline range. So again, I think that the 3 sentencing hearings together, where there was a lot of confusion in the first hearing, where the court explicitly said that it would impose the same sentence, might have been tempered after when the court came back and talked about clarification of giving him some counseling that he needed, and talking about how it did not consider his arrest record, which was one of the issues of confusion at the original hearing, that it was not going to consider just his arrest record, and that it understood that the guideline range was 120 months was the statutory maximum and was not 120 to 150 months. But again, in the initial sentencing, had focused on his characteristics and said that and in the second hearing said he got a break from the 120 to 150 months. I just think it creates enough confusion that it's far from certain that that's the sentence the court would impose if it was faced with a 92 to 150 month guideline range, and again could consider his adverse childhood experiences. If there are no further questions, I'll rest on the brief.
All right. Thank you, Mr. Anderson. You have 2 minutes.
Thank you. I'd just like to hone in a little bit more on this offer issue. As I point out in the brief, South Carolina says that we're supposed to give meaning to every word in the statute if at all possible. And what I heard my colleague over here say is that an attempt, quote, inherently encompasses an offer, close quote. If that is true, then there is no need to have attempt in the statute because every attempt has an offer. And so I did not hear him discuss the statutes that I cite, like the hazing statute that has threatens and offers. And so it must mean something. And this court doesn't necessarily have to say what it means, but if the court finds that offer is any broader than a threat, it's overbroad and it's not a crime of violence. So again, you don't have to necessarily opine, but it has to be.
Well, no, we have to find that offer doesn't require a mens rea of greater than recklessness. It doesn't matter if it means, you don't win automatically if it means something broader than attempt.
That it has to be an use, the attempted use or the threatened use of force. And so if an offer is broader than threat use of force, then it's not a crime of violence. And again, the guideline would drop. And so I just wanted to point that out there. And if the court has no further questions, I'll stand on the brief.
All right. Thank you. Thank you. Well, this case was well briefed and well argued by all 4 of you, and we appreciate it. Mr. Shoemake and Ms. Stoughton, we also thank you for your work on behalf of the United States. And Ms. Arbro, we very much appreciate the important work you do every day on behalf of indigent clients. Mr. Anderson, in particular, we want to thank you for, I know you're court appointed, and we want to acknowledge that and thank you for your work on behalf of Mr. Mack. And I'll ask the clerk to adjourn court.
Honorable Signed, die. God save the United States and this honorable court.